So over the past few weeks, I've cited and carded the Cox opinion many times in my videos. This was the opinion where the internet service provider, Cox Communication, did not have a termination policy. The DMCA, 17 U.S.C. 512, the limitations on liability established by this section, which is the service provider's safe harbor from liability, no liability for Cox Communication if, and only if, they adopt and reasonably implement and inform subscribers of a policy that provides for termination of subscribers who are repeat infringers. And the Cox decision said that Sony Music and a whole bunch of other plaintiffs, this entire page is plaintiffs, and I think there's even more plaintiffs down here, so I will need to zoom out to get all of these plaintiffs onto one page. All of those plaintiffs sued Cox Communications for not implementing a termination policy based on copyright DMCA takedown notices, and so Cox was liable for, I believe it was a $1 billion copyright judgment, which Cox is now appealing, understandably so. But instead of going over Cox's appeal today, I want to go over the new amicus brief from the Electronic Frontier Foundation, which was written by Mitch Stoltz and Corinne McSherry. This is the brief of amici curiae, or Friends of the Court, coming from the EFF, the Center for Democracy and Technology, the American Library Association, the Association of College and Research Libraries, the Association of Research Libraries, and Public Knowledge in support of Cox. Now, Attorney Stoltz wrote about this on the EFF's website, and I'll provide a link in the description below. I'm not going to go through his post because you can go through his post yourself if you want a summary of that and don't want to listen to me reading the brief of the amici curiae. But I think it will be interesting. It's not that long and it should go pretty quick. When you look at briefs like this, there's a few things you should look at. You should look at the table of contents because these are often written as outlines. They're going to argue that the court misread the secondary liability doctrine of copyright liability, that vicarious liability requires a meaningful ability to supervise infringing activity, which ISPs lack. And I'm going to disagree with some of this as we go. I disagree with that one, but we'll explain that as we go. That terminating subscribers is not required to avoid a contributory infringement claim. That the district court did not meaningfully consider due process, fair notice, and public interests. That the verdict would cause harm to the public because people would lose their internet connection, including people who did nothing wrong. In other words, there's more than one person using an internet connection, so if any one of them does something wrong, they can all lose it. And that losing internet access is an extreme public harm. The core question in this litigation is whether an internet service provider was sufficiently aggressive in terminating the accounts of thousands of subscribers, and if not, the consequences of that policy decision. The district court's answer misconstrued the law, the actual relationship between ISPs and subscribers, and the public interest. Affirming it would have dangerous consequences far beyond this case. Every use of the internet, be it for political organizing, access to government services, healthcare, commerce, education, finding and forming a community, or simply entertainment, requires the services of an internet service provider. Terminating that service means withdrawing an essential tool for participation in daily life. Terminating an ISP account doesn't just cut off the allegedly infringing subscriber, it potentially cuts off every household member, or in the case of a school, library, or business, every student, faculty member, patron, or employee who shares the internet connection. And with little or no competition among broadband ISPs in many areas of the country, those users may have no other way to connect. Given this reality, the stakes of this case for internet users are enormous. The district court's judgment and the jury's damage award in this case are founded on fundamental errors of law that, if affirmed by the appeals court, will force ISPs to terminate more subscribers with less justification or risk staggering liability. First, the judgment relies on unwarranted extensions of copyright's secondary liability. doctrines, which will encourage ISPs to terminate subscribers when more proportionate means of addressing infringement exist. Second, the staggering and poorly justified $1 billion award of statutory damages against Cox thwarts basic principles of due process and the public interest. The purpose of the Copyright Act is enriching the general public through access to creative works. This purpose informs the limited scope of the copyright holder's statutory monopoly, including the proper scope of secondary liability, as well as the damages calculation. The district court's handling of this case lost sight of that purpose to the detriment of the general public. The court should reverse. So then they go into the secondary liability doctrines, which are vicarious and contributory liability. Vicarious liability for copyright infringement applies when a party possessed the right and ability to supervise the infringing activity and possessed an obvious and direct financial interest in the exploited copyright materials. This doctrine serves as a common law principle of respondeat superior, or rather that the employer is responsible for the employee, the agent is in charge of their wards or charges. Its canonical purpose is to prevent an entity that profits from infringement from hiding behind undercapitalized dummy operations. Consistent with those origins, the first element requires a showing of some level of principal-agent relationship between the liable party and the actual infringer. Under the common law, vicarious liability attaches to the principal of a non-employee agent only when the principal intended the harmful result or directed the manner of the agent's conduct. This principle gives meaning to the right and ability to supervise requirement. Subscribers are not agents of their ISP, and the ISPs cannot meaningfully direct or supervise the manner in which subscribers use the internet. Indeed, any finding to the contrary would sharply conflict with the public's understanding of an ISP's role. And my only disagreement with that is that the ISPs are doing this disconnection procedure after receiving DMCA takedowns. And while I think there should be some more due process to that, there's something in between. They cannot meaningfully supervise because they do have notice of these DMCAs, and doing nothing. ISPs compete primarily on the reliability and bandwidth of their internet connections. Customers subscribe because the subscription enables customers to transmit and receive data from the internet. ISP systems are largely agnostic to the applications that users choose to run or the contents of their communications, both of which are the domain of users themselves and edge providers, such as social networks, website operators, email providers, and so on. Federal and state regulators have worked for decades to enforce that agnostic approach, sometimes called net neutrality. When the ISPs have engaged in supervision by observing their customers' internet use in detail or attempting to control it, customers have generally found this intolerable, and ISPs have faced substantial fines. In some circumstances, ISPs may in fact be barred from observing their users' activities. Again, the termination requirement was based on receiving DMCA notices, and we can argue all day whether receiving a DMCA notice counts towards that termination requirement, but I don't think that requirement is the same thing as an ISP having to observe their users' internet activities. I think maybe that's going too far, but let's have a discussion in the comments below. Various state laws forbid ISPs from using or disclosing users' web browsing history, application usage, and the contents of communications. It is no surprise the district court did not find that Cox had the right or ability to supervise. Instead, the court simply found it sufficient that Cox had the ability to terminate subscribers. But that's what the law says. A service provider shall not be liable for monetary relief, for injunctive or other equitable relief, for infringement of copyright by reason of the storage at the direction of a user. Actually, this is kind of interesting. So looking at this section A here, section A is transitory communications, section B is system caching, section C is the place where you are required to accept DMCA notices. And then section I requires everybody to have a reasonably implemented termination policy. So it doesn't actually say in this law that DMCA notices will be the thing that gets a service provider into this termination policy. But it does say something about being able to terminate subscribers who are repeat infringers. and then it just says in appropriate circumstances. What is an appropriate circumstance? So this is a legitimate dispute that I think we've got going on here. Instead, the court simply found it sufficient that Cox had the ability to terminate subscribers, but this is not the test for vicarious liability because anyone can terminate a principal-agent relationship whenever the parties' agreement permits. Vicarious liability must require more. In effect, by equating a right and ability to terminate with the ability to direct a customer's conduct, the district court eliminated the first prong of the vicarious liability standard altogether, contrary to decades of copyright jurisprudence. Courts have long distinguished between a landlord who is not held vicariously liable for infringement by tenants and a dance hall owner whose close participation in the activities that take place on their premises makes them liable when infringement occurs. That's the Fonavisa case and the Universal City case. Moreover, under the district court's formulation, in nearly all of the internet service cases where a court found the right and ability to supervise infringing conduct lacking, the court should have found liability instead because those service providers too were able to terminate accounts. And then they go on to talk about contributory copyright infringement, which requires knowledge of the infringement. The district court held that a service provider with knowledge of specific acts of infringement is liable for those acts if it can take simple measures to prevent further damage to copyrighted works, but fails to take them. I mean, that sounds like the termination policy. But the district court misapplied this standard. First, the court's jury instructions that plaintiffs have established that Cox had specific enough knowledge of the infringement occurring on its network that Cox could have done something about it implies that Cox could have done something in response to notices of the infringement, but it did not. In fact, Cox presented evidence that it warns, remonstrates with, cajoles, and threatens subscribers whose accounts are subject to infringement accusations, and that its communications are effective at stopping most infringement. But then remember, the district court's decision was based on Cox having a 13-strike policy, and it didn't even implement that. It would reinstate accounts even when there were 12 or 13 strikes. It would disconnect somebody's account and then immediately reinstate it, or shortly thereafter reinstate it. The jury instructions suggested that these efforts did not matter and that something more was needed, terminating accounts, the only thing Cox was reluctant to do. The district court's narrow focus on termination reflects the Digital Millennium Copyright Act's safe harbor provisions. That statute creates a shield against most infringement remedies for certain service providers who comply with its terms. One of the requirements is that termination policy that we talked about. ISPs that do not adequately implement such a policy may lose their safe harbor. Although ISPs that do not adequately implement a termination policy may lose their safe harbor, that is a separate issue from whether or not copyright infringement has occurred. This court has made clear that the DMCA does not change or supplant the judge-made doctrines of copyright liability. The statute leaves courts free to continue to construe the Copyright Act in deciding the scope and nature of prima facie, or on its face, liability. Unlike the DMCA safe harbor, the doctrine of contributory liability does not require ISPs to terminate subscribers in order to avoid liability. Contributory infringement applies only when a service provider has knowledge that infringement is substantially certain to result from their continued providing of the service. Cox's remonstrances and warnings to accused subscribers made continuing infringement far from certain because nearly all heeded those warnings. Thus, under this court's standard, Cox did not necessarily have the requisite knowledge, but the district court's instruction ensured that the jury would not fully consider that possibility. What I think they're trying to say here is that when you lose your safe harbor, that doesn't mean you're liable. That means you can then be held liable through another proceeding, through a claim. So you can't just say, oh, you're out of your safe harbor, I get money. You have to say you're out of your safe harbor and this copyright law applies and therefore you're in violation of the copyright law. So you have to go through the entire secondary liability analysis as well as pleading that someone is outside their safe harbor. You have to prove both things. And what Attorney Stoltz and the EFF are saying, and the rest of the amici curiae are saying, is that the district court's analysis didn't consider the entire scope of secondary liability. The consequences, if left unaddressed, will reach far beyond the case. Requiring termination when other measures are effective to address infringement will cause ISPs to terminate customers more often than necessary. That outcome will not serve the public interest. Then they go into due process concerns, and I'm going to sort of accelerate through this a little bit. The district court's reasoning would vitiate or eviscerate the concept of fair notice by allowing unbounded liability for ISPs. The district court's view of the public interest poses a significant risk of harmful over-deterrence. The district court should have considered the award's likely effect on internet users who bear the brunt of stepped-up, inflexible copyright enforcement. So we're going to learn about fair notice. The due process clause imposes substantive limits beyond which penalties may not go. These limits apply to copyright statutory damages. Due process requires fair notice of the severity of the penalty that a state may impose. Here, the district court found Cox received fair notice based on a simplistic formula, as there is no potential ambiguity in construing the statutory damage or dollar amounts, and Cox was keenly aware of the volume of infringement notices it's received. The product of these two values was reasonably foreseeable. According to this formula, however, ISP defendants would have to foresee potentially infinite risk. As the district court acknowledged, Cox received nearly 5.8 million notices during the claim period. If statutory damages had been awarded for each of these infringement notices, the aggregate award would have been an absurd $580 billion. And yeah, this brings up echoes of the LimeWire case, where LimeWire was reported to be liable for trillions of dollars of infringement. But when it came down to it, I don't recall that the district court was actually asked to hold LimeWire liable for trillions of dollars. That was the Arista Records versus Lime Group case. And when we look at the reporting of estimated damages, the reports were that the music industry was asking for $15 trillion in damages, which would be absurd. But the plaintiffs never explicitly asked for a specific amount of damages. The exact calculation was left as an exercise for the court. The press was the party that circulated multi-trillion-dollar estimates. So that's where that came from. But yeah, $580 billion would be a lot. My response to that is that we're not calculating damages by the number of notices. We're calculating damages by the number of titles. So it would have been a damage award for a number of titles, and that's where the jury got their $10,000 times, I think it was a lot of notices, and got to $1 billion. What is worse, the only practical limit the district court identified, Cox's cap on the number of notices accepted, was itself a source of risk, as plaintiffs claimed this practice was an unreasonable implementation of Cox's repeat infringer policy. I mean, you kind of can't deny that Cox didn't implement a repeat infringer policy properly. That seems to be pretty well established here, and the dispute here is about whether the damage award was proper or whether the secondary liability doctrines were properly applied. The jury based its eventual damage award on the number of works rather than the number of notices. What did I just say? But that number was also not reasonably foreseeable. The statute itself is clear. All parts of a compilation or derivative work constitute one work. Okay, so maybe if a registered copyright is for a music album, then you get one award per album. And yeah, there you go. If that was what the damage award was calculated on, was the number of songs instead of the number of albums, you'd have to do the analysis for each album, whether it was the album that was copyrighted or the songs that were copyrighted. It will make a big difference. The district court itself acknowledged that congressional intent behind this provision is to shield the defendant's potential liability from undue manipulation, yet the district court agreed with Cox that the number of works supported the jury's award and was inflated in a manner inconsistent with the text and intent, yet still allowing that number to stand. Fair notice requires more, particularly where, as here, the claim is for secondary liability. ISPs do not have the same knowledge or insight into the number of works behind a damage award as a direct infringer. For example, in Capitol Records, the defendant arguably had fair notice of the number of works at issue because she placed them into a shared folder. It doesn't overcome my argument as to whether it's an album or a song. The Eighth Circuit rejected fair notice concerns and reliance on Campbell and the Gore case because the authorizing statute identifies and constrains statutory damages. No such constraint applies here. The district court misconstrued the public interests. Now we're doing fair notice and public interests. The award far exceeds what is reasonably necessary to vindicate legitimate interests in punishment and deterrence. Due process requires consideration of the disparity between the actual and potential harm suffered by the plaintiff and the punitive damages award. Although the Supreme Court applied this as punitive damages, not statutory damages, its application to copyright is appropriate given that those damages serve purposes of both compensation and punishment. Secondary liability cases are unusually likely to lead to disproportionate and unreasonable awards. That is what's happening here. Unwilling to estimate actual harm, plaintiffs instead invited the jury to punish Cox for harms suffered by the entire content industry. The district court endorsed this approach, relying on the Thomas Rasset case. So yeah, that was the Jamie Thomas Rasset case where major record labels tried Jamie Thomas Rasset liable for making 24 songs available for free on Kazaa and ordered a payment of $220,000. The original award of $222,000 was apparently constitutional. The Supreme Court denied certiorari, and Thomas Rasset apparently never paid. I'm not sure if she declared bankruptcy. Back to the Cox appeal, the district court endorsed the Thomas Rasset approach, finding that consideration of industry-wide harms justified an award of many multiples higher than actual damages. I mean, that's what statutory damages are for, to avoid having to prove actual damages. But while damage awards should demonstrate due regard for the interests of the public, copyright awards may implicate multiple public interests. Outside disproportionate awards can overdeter. That can inhibit new creativity and innovation, which would violate the principles of copyright to promote the sciences and useful arts. And when the disproportionate award falls on the ISP, the cost of overdeterrence may actually fall on users more than the ISP. The likely response of Cox to a $1 billion award will be to more readily terminate accounts, and as a result, all users of an account accused of repeat infringement would bear the consequences of stepped-up enforcement, surveillance, cooperation with right holders, and termination. So disproportionate harm to the public is probably going to be cutting off users' ability to participate on the internet. So their next argument is that more aggressive termination policies will punish innocent people as well as guilty parties too much. Cox was right to hesitate to terminate accounts. Given the $1 billion damage award, Cox would not hesitate again. Even for residential accounts, the consequences of terminating internet access will not be confined to individual repeat infringers. Let me be absurd for a moment here, but wouldn't a subscriber who provides internet access to multiple users, wouldn't they then need to implement the DMCA safe harbor if they wanted to be in the DMCA safe harbor and be safe from being liable for termination because of their users? They would just pass the DMCA notice on to the user. But then, of course, that would make every residential subscriber who has multiple users a commercial internet provider or a wholesaler. I don't think internet service providers would like that either. In other file sharing cases, rights holders have estimated that 30% of the names of account holders identified as infringers were not responsible for the alleged infringement. That figure is unsurprising. Almost 8 million US persons accessed the internet at home without a paid subscription in 2018. More than 77 million subscribers use the internet at someone else's home. As one terminated Cox subscriber stated, one cannot control what everyone does on the internet in one household or business. Multiple user accounts are especially common in shared households, etc. So the EFF is saying that multiple innocent people will be terminated when one person misuses the internet. That's a valid concern. And then there will be a disparity where it will be worse for people who only have access to one internet service provider. And they go on to state how a lot of rural places don't have high-speed internet or more than one provider. They lack options, the wrong side of the digital divide, which affects low-income families and communities of color the most. Rural areas, tribal lands have limited ISP options, often because providers have little economic incentive to build out services in sparsely populated areas. So losing internet access is an extreme public harm. They reinforce how useful the internet is. It's COVID-19, so it's especially useful, and that it's against public policy to want to disconnect people. Employment could be affected as well. Health could be affected if you can't get an internet connection. So people who are employed might need to remotely work. People who are in medical need, which is really anybody at any time, can't get access to remote health solutions. It's going to affect a lot of people. I see how the case needs to be rethought, but the question then becomes, is it a court that should rewrite the way the law is written badly, or is it Congress's place, which we have to forget for a moment that Congress doesn't really work too well right now. But is it Congress's place, hypothetically or theoretically, to rewrite the law themselves? And in my opinion, it's Congress's place to rewrite a badly written law or a law that had unintended consequences. But I see what the EFF is doing, and I think this is a brilliant brief by the EFF and Attorney Stoltz and Attorney McSherry, but I do think there are some flaws here that might lead to the Cox case being affirmed, which you might not have been able to overcome anyway, but it's the EFF's job to do stuff like this. They conclude the decision below impermissibly lowers the threshold for a finding of secondary liability, which I think is their strongest argument, and increases the likelihood of secondary liability posing an existential threat. I think that's a weaker argument. The consequence of that decision would be the loss of internet access for an untold number of internet users, regardless of whether they engaged in any infringing activity, which I think is on Congress to rewrite. Neither copyright precedent nor any legitimate interest of copyright holders justifies this result. I think that's a philosophy, but I don't know that that's the law. But I'm interested in following this because this is a really interesting case to me. I hope it's a really interesting case to you. Let me know what you think in the comments below. Thanks for watching. This channel would not exist without your support on patreon.com/ljfrench, sponsors.com/law, Floatplane subscriptions, and YouTube memberships. Special thanks in the month of June to the following supporters: Joe Tyson, John Steele, Gavin Barnard, Evie, Spirit Bear, Benjamin Hightoff, Ugly Grill, Rudolph Bescherer Jr., Torpedon, Brandon Abel, Shadow Tycho, Earthbound Star, RDH Dragon, and Pure Magma. And thank you to the rest of our supporters scrolling on the screen in front of you. I'm Leonard French, your favorite copyright attorney. I love you all. I'll see you in the videos. Have a great week. Bye. I'm not gonna touch your baby. I promise. Here, on 3 separate occasions, Ronald Fifth smiled.